I figured that Thomas Clare Binger was about the most detestable creature there was around, but I was wrong. James Krause owns that title. I don't know how this guy slipped under my radar for so long. I mean, he was actually a very active figure in the whole court proceedings, but for some reason, I seem to have let his shenanigans get past me. But then I started looking at his closing arguments, especially in more detail. And the only thing I can think of is that this dude is loco. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dread Show.
It simply cannot be reasonable for someone to be holding an AR-15 semi-automatic rifle with powerful ammunition and be chased by someone who is unarmed, who's smaller than him, who's shorter than him. And the first thing that you do to defend yourself is you plug 4 rounds into it.
Joseph Rosenbaum is smaller than this dude by a wide margin, and I mean a wide margin. But Joseph Rosenbaum would absolutely kill this dude if they ever got into a fight. It wouldn't even be close. He outweighs JoJo by probably a good 150 pounds, maybe even 200. But my money is on Rosenbaum in a fist fight. So I fail to see what the big deal is about the size. I've said this before in another one of my dumb argument series. JoJo Rosenbaum may be small, but he can fight. He's been in prison. He's been in trouble in prison. He's had numerous battles in prison. He knows how to fight. And Kyle Rittenhouse, he doesn't have nearly the kind of experience, nor does he have the attitude. And winning a fist fight is often about attitude. So, yeah, I don't want to hear it, James. Don't give me this Chuck Connors crap.
You shoot it from about 4 feet away, and not from 4 feet from Mr. Rittenhouse, 4 feet from the end of that gun. Your first shot immobilizes him. It shatters his hip. Then he's caused to go forward. And if you watch the videos, and we're going to watch a couple during this brief rebuttal, he crumples. He immediately crumples to the ground. This case is about the right to use deadly force. And I want to talk about that standard because Attorney Richards, perhaps on accident, misstated it. He said that the standard is that it could cause death or great bodily harm to Mr. Rittenhouse, or that it is likely to cause death or great bodily harm to Mr. Rittenhouse. That is absolutely not what the standard is. And that is not what this trial is about. The standard is the defendant may intentionally use force which is intended or likely to cause death or great bodily harm, such as fire an AR-15, only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself.
Okay, let's not gloss over this, James. It says the defendant reasonably believed. Therefore, it is not required. Know that the force would have caused. That's hindsight.
Not, oh, if you repeatedly smash someone's face, it might lead to injury. Not, oh, this could have happened. Imminent death or great bodily harm.
Reasonably believe that it could. That's all that's required.
There's an old phrase that I could kill you with my bare hands. And there is literally no evidence that Mr. Rosenbaum was capable of that.
Do you have any evidence that he wasn't?
Mr. Rittenhouse has size on him. We heard how he's a swimmer. We heard how he's a lifeguard. He's apparently in some kind of shape.
JoJo is not in bad shape. But again, JoJo has a lot of experience in fistfights, and he has the attitude to knock it through. He's going up against a 17-year-old kid, a minor.
Punch him in the face. Kick him in the testicles.
This is like watching the British version of The Office. Like, it's funny, but awkward and sad at the same time.
Yes.
Hit him with your gun. You don't just immediately get to shoot someone. And
Actually, hitting him with the gun would constitute assault with a deadly weapon. And since you could not really claim that you were trying to stop the threat, because stopping the threat, you could have used the actual bullets coming out of the gun to do that. Therefore, you lose your protection. If you have a loaded rifle and you turn around and you use the butt of that to try to stop an attack, you're taking your chances there. Because these guys would then come in and say, you could not have suspected that you faced an imminent threat because you could have shot the person, but you didn't. You avoided taking actions that would have stopped the threat. Now, I'm not a lawyer. Don't take my word for any of this, okay? If you're going to be carrying a weapon, you really need to talk to your lawyer. Make sure that your state law supports your stances on things, okay? But I'm telling you, you think that these two dudes, Binger and Krause, would have supported Kyle if he had turned around and hit JoJo Rosenbaum with the butt of the rifle? Forget it. It's assault with a deadly weapon, and for one for which you really don't have much of an affirmative defense.
And I don't care about provocation or any of that. Put that aside. It is not reasonable for any adult, for any person, for any...
He goes, for any adult, and then all of a sudden he thinks, oh, wait, let me backtrack here.
17-year-old male to not try and defend yourself first using other methods. Now you factor in provocation, the fact he had no right to retreat, or no ability to, or he had to retreat, and that he had to exhaust all methods. Clearly, if there is provocation, he's guilty. But even outside of provocation, why do you get to immediately just start shooting?
Okay, he talks about exhausting all methods, and he said initially, put aside provocation. Let's forget about provocation. So what does Wisconsin law say about exhausting all options? Let's take a look and let's read it. There's only one place here in 939.48, which deals with self-defense, where the issue of exhausting all possible options comes up. And it's right here. Let me read it. In such a case, the person engaging in the unlawful conduct is privileged to act in self-defense, but the person is not privileged to resort to the use of force intended or likely to cause death to the person's assailant unless the person reasonably believes he or she has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. Okay, but where is that being read? It's right here, under provocation.
As Mr. Binger said, he brought a gun to a fist fight. And he was too cowardly to use his own fist to fight his way out. He has to start shooting. And let's just say, theoretically...
Yeah, I'm sure you're a regular Chuck Norris.
That we think, that the 12 of you think that it is reasonable to have used force, deadly force in that situation. Shoots once, takes out his hip. What does Mr. Rittenhouse have to do to avoid that? Well, maybe take one step back. And Mr. Rosenbaum is no threat.
Yeah, none of this is going to fool the jury. They know fully well that Kyle squeezed off the rounds really rapidly. All four of them in under a second, about 3/4 of a second. They know better. I have no idea why he's even trying this.
And Mr. Rittenhouse is responsible for every round of that gun. It did not have to happen as fast as Mr. Rittenhouse made it happen. He could have held back at one shot. He could have held back at 2 shots.
Hey, as far as I'm concerned, if I'm on the jury, I'm thinking, oh, why should he? He doesn't have to stop after one bullet.
The guy in the blue hoodie who came in to attempt to kick him didn't get 4 shots. Mr. Rosenbaum didn't get 4 shots. And Mr. Grosskreutz did not get 4 shots.
Doesn't that show restraint on the part of Kyle Rittenhouse? That's what I'd be thinking if I'm a jury member. Hey, you're right. They didn't get 4 shots. They only got 1 or 2. But he easily could have shot him that many times. Why didn't he? It's restraint.
Hit him, kick him, knee him, anything else. And Mr. Rosenbaum and Mr. Rittenhouse are alive. Because the defense talks about games.
Yeah, he's making the claim that Rittenhouse would still be alive. Yeah, what happens if Rosenbaum gets a hold of that rifle? Then what? Is he going to guarantee that Rosenbaum is not going to shoot him? What guarantee is that? I just had a video on my channel where this one dude took an officer's gun from her and then turned around and executed her. That easily could have happened here. And Rosenbaum was probably more nuts than that other dude.
And he talked a lot about the Zeminskis. He knows darn well that the Zeminskis are charged by my office and they have a Fifth Amendment right. This is a criminal defense attorney. Stop. And he talked a lot about the Zeminskis. He knows darn well that the Zeminskis are charged by my office and they have a Fifth Amendment right.
Notice he said the Zeminskis, including Kelly and Joshua. And then he's going to later claim that that's not what he said. Watch.
I did say Mr. Zeminski had a Fifth Amendment right, and then the objection came. I did not say Mrs. Zeminski.
He's saying, I did not say Mrs. Zeminski. He's claiming that he did not include her in his statement. What a liar. He said the Zeminskis and they. Obviously, he was including both Joshua and Kelly.
I'm the Loco one in this game.
Ms. Zeminski was charged and convicted by my office. Mr. Zeminski still has pending charges. Attorney Richards knows that he has a Fifth Amendment right to not testify.
You can. Let me ask you to step in the library again, please.
The jury is getting more exercise than James ever got.
Now let's talk about this threat, this supposed threat. Mr. Richards talked about that gas station and showed the video, and it showed Mr. Rosenbaum at the end. Attorney Binger had said he's not in this video as it started and you don't hear anything from him. And that is true. At the very end, he is seen standing quite a bit away from Mr. Balch and Mr. Rittenhouse. This is where that supposed threat happened. There's a distance between them. Next time the camera pans back, the protesters are pushed back. And you never hear this threat. You hear nothing. And apparently that is what the defense is accepting, is where the threat happened, although Mr. Rittenhouse actually does not accept that, because he said it happened at Block 2 North. So they can't agree on when the threat took place. They can't agree on where the threat took place. And it's the only few seconds of that part of the night that is not on tape anywhere. It's another concoction to give credence or to give weight that, he had to defend himself against an unarmed man.
Ryan Balch was his witness. They called him to the stand. And now he's in there saying, well, you can't trust that which Ryan Balch said. Okay.
The defense themselves submitted an exhibit, number 41, in which it is denoted where the person that put that video together indicates Rittenhouse pointing gun at Zeminski's. I think it has a question mark.
That's right, he has a question mark on it. He's not noting that that's where Kyle is pointing the rifle at the Zeminskis. He just put a question like, could this be? That's Orkanut, by the way. So just because the person who put the video together has a question about whether Kyle was raising his gun at the Zeminskis is not evidence that Kyle was in fact raising his gun at the Zeminskis.
This was their exhibit. There was testimony from Detective Antaramian. And we showed this drone video. Now, but then the defendant won't admit to it on the stand, and then all of a sudden the defense has to fight it and talk about hocus pocus and make up little clever rhymes.
You put up a really blurry video that nobody can figure out, and now you're attacking the defense because they fought against your use of it.
The defendant could have told you the truth, but that hurts his case, and that gives us provocation. Now,
yeah, well, here's the issue, though. You have to prove that Kyle was actually pointing the rifle at the Zeminskis before you can say that he was lying. However, that video did not show that at all. I doubt anybody on the jury thought it because it's blurry as hell. And if you actually look at it with a critical eye, you'll realize that the Duramax rearview mirror was mistaken for Kyle's right hand, making it appear like Kyle was pointing his rifle at the Zeminskis, who I guess somehow must be about 10 foot tall, because Kyle is pointing the rifle up at probably a 30-degree angle. Were they in the trees?
I did have, on rebuttal, Mr. Armstrong put in two very blurry pictures. Mr. Binger didn't even mention these pictures in his closing because they're maybe the fifth, sixth, or seventh strongest pieces of evidence that Mr. Rittenhouse raised his gun. But the defense is seizing on them, and they inaccurately said that it took him 20 hours of work to do. He worked on that drone video for 20 hours. He made us multiple shorter videos of it. These images were the last part of that work. And that image does show Mr. Rittenhouse holding a gun. It is blurry. Does it show every detail? No.
Yeah, that's right. And so it's really rife for confirmation bias. Essentially, you see in it what you want to see, but it's very clear that guess what? The rifle was not pointing towards Kyle's right and up. It was pointing down and towards the left, like Kyle was holding the rifle all night long. And keep in mind, with the strap the way it was on Kyle's body, Kyle couldn't have pointed the gun up towards the upper right without twisting his body. It's ridiculous.
And despite the fact that there's this madman out there who's such a threat and is going to kill the defendant, he just saunters down there all by himself. No problem. He's not scared. This threat...
Because he has an AR-15 rifle. That's the whole point of having the rifle.
If it even existed, was not taken seriously. He's a babbling idiot, as Mr. Lukowski said.
A babbling idiot can still be dangerous.
Guns do not have handed. There's not a left-handed or right-handed gun.
He's crazy, man.
That's not true at all. Where in the hell is he getting that? By the way, I'm left-handed. Don't tell me that guns are not left-handed or right-handed.
A lot has been made about how Gage Grosskreutz had an attorney. How hypocritical from a lawyer to hear someone criticize someone else hiring counsel. Mr. Rittenhouse isn't here alone. He has lawyers.
Yeah, that wasn't the issue. The issue was Gage Grosskreutz didn't have just any lawyer. He had the dumbest lawyer you could possibly imagine. And guess what she did? She filed a lawsuit against the city and the county before Gage Grosskreutz took the stand. And that gave all kinds of ammo to the defense because that is an obvious conflict of interest there. It's obvious bias. You're going to want to make money, and guess what? It's easier to make a lot of money on a lawsuit if the defendant is convicted. If she had not done that, they would have had a harder time. Therefore, the fact that Gage Grosskreutz hired Kimberly Motley and that she had him file a lawsuit against the city and county is kind of important.
And I apologize that the District Attorney's Office followed our interpretation of Marcy's Law, which is a fairly recent, especially at that time, constitutional amendment.
Mr. Richards, don't wait here yet.
Gage Grosskreutz is not on trial. He followed the advice of counsel not to turn over his phone. Just as
He followed the advice of Kimberly Motley. Okay. Actually, she probably got this one right, but whatever. I would never do a damn thing she says.
anyone who hires counsel can do. They can follow the advice of their counsel. We got his whole video from that night. The defense has seen it. We have it. What else do we need? Text messages from 3 weeks before?
We don't know, because usually that's why you actually get control of the phone and extract the data from it, is to find out what's in it. If they knew what was in it, they wouldn't need to do that.
They just want to try to dig up dirt because they think it's there, because the defense wants you to believe that these people got what was coming to them. That they were bad people doing bad things, and we should be proud and boastful of Mr. Rittenhouse for killing them. Gage Grosskreutz testified what he heard, that he heard, I didn't shoot anyone, and Gage Grosskreutz acted on that. He then followed, he left Mr. Rittenhouse thinking that he was not involved in the shooting, and started going to the shooting of Mr. Rosenbaum before being told by others that saw it that he was the shooter, and then he returned. So Gage Grosskreutz relied on this statement of Mr. Rittenhouse.
If I was the prosecutor, I would drop all mention of Gage Grosskreutz. That was embarrassing, and you getting out here and trying to convince the jury that somehow Gage Grosskreutz is helping your cause, no one's going to buy it. In fact, you probably would have been best to go ahead and drop the charges against Kyle Rittenhouse for the attempted murder of Gage Grosskreutz after Gage testified. That would have actually strengthened your argument when you went here in your closing arguments. But instead, you kept him. Gage testified that he pointed the gun at Kyle. That was it. You're toast. Drop the charges, and that way it makes it look like you're being fair and even-handed. But no, you kept them because you wanted to convict the kid for everything you could.
We heard from Ms. Carrie Ann Swart. Now that Nathan DeBruin talked about jail, now we can try to smear Mr. Rosenbaum more, although there really is no dispute, or was no dispute, that he came from a hospital. He's carrying a hospital bag.
A mental hospital bag. He will not mention that at all.
Ms. Swart testified that she talked to the hospital about how he would be released, that he went to this hospital. She knew he was coming home from the hospital. She knew it was in the bag, and he showed that picture of it backlit against the fire, trying to make it seem sinister. She talked about how there are medical papers in there. And we did that image again. Mr. Armstrong did this image for us, where you can get a little peek in the bag. And I would argue you can see medical papers. Though that big image they see, it looks like rolled up medical records that you get when you're discharged from a hospital.
From a hospital, not a mental hospital? The dude was nuts. Own up to it. The jury's not buying this.
And Ms. Swart testified that he was given medications that day. Perhaps they didn't work. Perhaps there was a bad reaction. I don't know. I'm not a doctor. But
perhaps it was a bad reaction to it. What are you implying?
Third, field. Yeah. I'm crazy. I'm the loco one.
Balch did not testify that he thought there was anything sinister in the bag. He said he said something inaccurate at the time, but he said that he saw He did take some nice photographs, and he clearly wanted it to work. Mr. De Bruin.
Which everybody on the jury thinks this was a really cool dude. He's okay. Down to earth, genuine. Oh, let's attack him in the closing arguments.
He did take some nice photographs, and he clearly wanted the world to know that he took some nice photographs.
With a camera. It was really good that we were able to establish that he had a camera with him thanks to your brilliant cross-examination.
He's really more relevant to Mr. Zeminski. And he apparently, this is the photo of the bag, you can examine that further.
If he's more relevant to the Zeminskis, then I would suggest not even talking about him. Because he's a very sympathetic character to the jury. Attacking this dude is not going to help you.
Mr. De Bruin must have some problem with police and DA's offices.
No, he has a problem with your DA office. I don't think he has a problem with DA's offices in general.
He goes to the detectives. He doesn't give a full story. He says, he testified to this. This is not me saying anything. He forgot things because he was so nervous because the door to the police station still had an unrepaired window. That caused him such nervousness that he could not give a full statement.
Just an unrepaired window? No, the window was broken out by a riot. That was the issue, and the jury knows that. Come on, quit trying to snow them. He's a sympathetic character. Move on. Talk about somebody else. You're not going to get anywhere by attacking Nathan De Bruin.
He meets with us in a very polite, short meeting. He has
short because you guys basically drove him crazy.
Very little relevance to this case that we knew about. And yes, we showed him some videos. Is this Josh Zeminski? Oh, no, it's not. Okay, would you see him in these other pictures? Yes. You don't know it's Josh Zeminski? Okay. Somehow that's us getting him to change his statement. What's that? We show him pictures, videos, say, is that Josh Zeminski? I don't know. We show him other pictures. Do you recognize that as the same person? Yes. That's not getting him to change his statement. We had him read his statement. Do you have anything to add to it? No. The next day, he goes over to Mr. Richards' office. All of a sudden, he knows all this extra information that wasn't in his statement.
All of a sudden, he encounters an attorney that doesn't make his stomach churn. So he's more talkative.
Oh, but he was so nervous meeting with us because we showed him a video or photograph that he took of Joshua Zeminski. And then what does he do? He goes and hires a lawyer very closely connected with a gossip blogger who attacks my office on a regular basis and who is very pro Rittenhouse. And then what does he do? He goes and hires a lawyer very closely connected with a gossip blogger who attacks my office on a regular basis and who is very pro Rittenhouse. And then what does he do? He goes and hires a lawyer very closely connected with a gossip blogger who attacks my office on a regular basis and who is very pro Rittenhouse.
Oh, golly. I feel so bad for this guy. He's going around and being attacked by this gossip blogger. It's the Kenosha County Eye, and the dude's name is Kevin Matthewson. Okay? But do you really think the jury is sympathetic to you? Oh, man. Shut up about the gossip blogger. That's your own personal problem. The jury doesn't give a shit.
We know that Mr. Rittenhouse was going around that night trying to be a paramedic, a policeman, and a fireman without receiving any real training in any of them.
And I think the jury would say, well, that's good. He was helping our community. Unlike you-know-who.
Tough job to do all three at once.
Much easier to just burn shit down. That's not hard at all.
And he went around with his gun trying to scare people, to intimidate them, to not do minor property damage.
Minor property damage. Oh, that's all that happened in Kenosha was some minor property damage. He's telling this to the jury. This takes balls.
I'm the most local person in here.
He's a chaos tourist. He was there to see what was going on, act important, be a big deal. And then,
by the way, he got the term chaos tourist from that Paige Williams article. The one that Wendy Rittenhouse said was so fair to her son. Still think so, Wendy?
you put yourself in this situation, you know it's going to be out of hand, it gets a little out of hand, someone is chasing me, and you have to shoot him.
Yeah, he had to shoot him. I have no problem with it. Don't like it? Don't go chasing him.
Now, there's talk about how the defendant maybe have re-racked his gun. We don't see that in the video. We don't know what he did. But we do know that as Gage Grosskreutz is sitting there with his hands up, the defendant turns over his gun and is looking at it and is doing something with it. The defendant admitted to this, that he looked at the gun.
Good grief, get off Gage Grosskreutz. The dude totally submarined your strategy. Everybody on the jury heard it. So do you keep propping him up as if he's really there to help your case? Is not going to win the day. You probably just should have shut up about Gage Grosskreutz altogether.
I don't know what he was doing with his gun, but it's certainly reasonable for Mr. Grosskreutz to interpret it that way. And then what does he do? He doesn't step back and take a firing position and shoot. He didn't shoot him 5 to 6 seconds earlier when Mr. Rittenhouse was being an active shooter, after having killed his second person and shot at his third. He would have every right to have stopped Mr. Rittenhouse's activities at that point.
By doing what? He said on the stand that he would never have shot Kyle Rittenhouse. Then what was he going to do?
But he didn't. He came up closer, he surrendered, and he said, he believed his surrender was not being accepted. Who shoots someone like this? Is he trying to shoot his own hand off? He never does anything about an actual position to shoot that gun. And as Mr. Richards admitted in his closing, when it's pointed at his head, his arm is already blown off. We're supposed to be so scared of Mr. Grosskreutz with his Glock when the defendant is holding a loaded AR-15.
It's more like, zany or goofy.
Yeah.
It's pretty clear to everybody that Kyle fired after Gage Grosskreutz pointed the gun at him. Good grief.
And now, a skateboard is a deadly weapon. Someone should tell all the parents and grandparents and Santa Claus giving skateboards this Christmas about how they're giving their children a deadly weapon. I guess they should get them an AR-15 instead.
That was Loco, but not in an entertaining way.
Okay.
Are you insane? This dude is crazy. I mean, anybody knows that a rock is a deadly weapon, but I can give a person a pet rock anytime. Can we arrest a bricklayer for possession of a deadly weapon? No. The weapon is deadly depending on how it is used. And guess what? A skateboard is a deadly weapon when you swing it at somebody's head. Hell, I have a video on one guy who was killed by being hit in the stomach with a skateboard. This is an argument that nobody on the jury is going to buy. They know fully well that a skateboard can be a deadly weapon, and if they disagree, then I can kindly walk up behind James Krause and ask him, would you mind if I nail you on the back of the head with this skateboard? I bet you 10 to 1 he wouldn't like it. He would probably say, oh no, that could probably kill me.
It's just preposterous. And yes, Mr. Huber was acting heroic in holding down that and taking that skateboard and trying to hold him down and trying to take that gun. And what happened?
Was he being a hero when he tried to kill Kyle with it earlier by running him from behind him and trying to hit him in the head with it?
The gun stayed attached to Mr. Rittenhouse. Because when the defense concocted this, they were trying to take my gun story, they left out that it is literally strapped to him. He shot an unarmed man 4 times because he was so scared that Mr. Rosenbaum was going to take the gun away from him when it was attached to him.
I tell you what, Mr. Krause, I'll give you an AR-15 and I'll let you strap it around you, okay? Now, the next thing I'm going to do is I'm going to show you how easy it is I can get that gun off of you. Now, you may think, oh, that's not possible. It's got one of those tactical military slings, okay? The rule is, if I can get the gun away from you, I get to shoot you. Gonna go for it? I promise you, I can take that gun off of him. Yes, the strap does make it harder. Yes, the strap is primarily designed so that it's easier to carry the rifle around. It's not designed so much to keep people from being able to take it from you. However, it does help. But under no circumstances is it true that because a person has a gun in a single point sling, that means nobody can take the gun away from them. They absolutely can.
These minor injuries we've heard the defendant have, again, Mr. Richards misstated the standard. It is not could have caused great bodily harm or death. It is not likely to have caused great bodily harm or death. It is imminent threat of death or great bodily harm.
No, again, it's whether the defendant reasonably believes there is imminent death or great bodily harm. I can't understand why Mark Richards is not objecting here. He's misstating the law.
Where is that when you get a couple scrapes? Everybody takes a beating sometimes, right? Sometimes you get in a scuffle and maybe you do get hurt a little bit.
You are so loco, man!
Okay. Is he seriously saying that Kyle should have just taken the beating? Are you insane? This is a minor, a 17-year-old kid going up against a 30-year-old, and you're saying that a minor should just be willing to take a whooping. And what about the women on the jury? How do you think they feel about this? You're telling the women on the jury that, you just have to be able to take a whipping once in a while. Yeah, your husband comes home drunk and he's being real abusive, but you just need to be willing to take it. Of all the stupid things to say, this one takes the cake. At this point, if I'm on the jury, I'm just going to tune this dude out.
That doesn't mean you get to start plugging people with your full metal jacket AR-15 rounds, and no, bullets are not bullets. And we heard testimony about that. Mr. Richards mentioned this in opening, but apparently he's noticed that the evidence doesn't bear it out. He talks about this, how Mr. Rosenbaum put this shirt over his head to hide his identity because he's going to go ambush Kyle Rittenhouse. Well, then obviously watch the videos. He's had that shirt on his head for some time. Whether it's COVID, this is all pre-vaccine, as we know.
Oh, yeah, it's COVID. Yeah, that's the reason why Jojo Rosenbaum was putting the T-shirt around his head, was to prevent himself from COVID.
Whether it's tear gas, whether it's fire, whatever it is, he's using it to protect his face, not as some evil plan to get Kyle Rittenhouse.
Tear gas and fire. Oh, you mean the things that he was doing? Right. it's pretty clear that he's putting the t-shirt around his face to protect his identity. Now, it may not have been aimed at Kyle specifically, but he was up to no good, and he was trying to keep people from recognizing who he was.
They're setting this fire, and they begin walking down Sheridan. There's no evidence that they knew he was coming. There's no evidence that they had any plan to get him. I'd submit to you that the Zeminskis and Mr. Rosenbaum were doing what they were doing all night. They were going to go bash that Duramax or start or stoke a fire. Kyle sees this, and then he runs onto the scene. That's clear in the FBI video. He runs onto the scene.
To do what? Put the fire out. He doesn't put that in there, but the jury knows it. Kyle ran to the fire to put it out like a good citizen. And by the way, they criticize that kind of action. According to them, Kyle should have let the car burn because he's not a fireman. When you see a fire, you shouldn't put it out. You should call the fire department. And if the fire department's not available, you're supposed to let it burn. Oh, you have a fire extinguisher? Put it away. You don't have the training to use that fire extinguisher.
He puts down the fire extinguisher. He raises up his gun. Mr. Rosenbaum yells, "Gun, gun, gun." Why else would he yell that? It's very possible that while he was yelling friendly, 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 he's doing so while holding a loaded AR-15 at the Zeminskis.
Again, there is no evidence whatsoever that that is true. The only thing they have is a video that is extraordinarily blurry, and it's pretty clear if you examine it that Kyle is not pointing the gun at the Zeminskis. Quite the opposite. The gun is pointing down and towards his left like it was all night.
Mr. Rosenbaum was going to chase him out of there to end the danger.
Yeah, according to this guy, Jojo Rosenbaum is a hero. That's what he's trying to tell everybody. Jojo Rosenbaum saw Kyle as a threat and was just chasing him away. Yeah, Jojo Rosenbaum, some hero. We saw him all night. You show me one instance where he did anything that was positive.
He raises the gun. He provokes the attack. He has to retreat. He has to exhaust all remedies before he regains the right to even use self-defense, not even to use deadly force. That's a whole other separate question. He does regain the use of self-defense if he exhausts all options. He does not. He could have ran a different way. He could have fought. He had all sorts of different ways to exhaust his options. He did not do it.
Okay, he's wrong and he's lying, and I don't understand why Mark Richards is not saying something here. Let's go back and play again.
He raises the gun. He provokes the attack. He has to retreat. He has to exhaust all remedies before he regains the right to even use self-defense, not even to use deadly force.
Not even to use deadly force, huh? Let's go read the statute. The person engaging in the unlawful conduct is privileged to act in self-defense, but the person is not privileged to resort to the use of force intended or likely to cause death to the person's assailant unless the person reasonably believes he or she has exhausted every other reasonable means to escape from or otherwise avoid death. In other words, the condition that a person has to exhaust all other possible means of escaping is only applied when he is facing imminent death or great bodily harm. It's right there in the statute.
That's a whole other separate question. He does regain the use of self-defense if he exhausts all options. He does not. He could have ran a different way. He could have fought. He had all sorts of different ways to exhaust his options. He did not do it.
That's not what the standard is either. Let's go back. I don't understand why lawyers can't figure out what the laws are because they're written. It says, unless the person reasonably believes he or she has exhausted every other reasonable means to escape. He does not have to exhaust every other reasonable means to escape from or otherwise avoid death or great bodily harm. He only has to reasonably believe that he has.
And fire an AR-15 in any circumstance like this shows utter disregard for human life. There's no other explanation for it. If you're shooting an AR-15 at close range of people, you have no disregard for human life.
Well, not if you're defending yourself legally. What the hell's he talking about? It's clear in the statutes that the affirmative defense of self-defense can be applied to reckless homicide. And it is quite possible for somebody to defend their life with an AR-15 at close range. Again, I don't understand Mark Richards here. I would be demanding, is there case law to support your claim? He's forming a legal conclusion here. Do you have case law to support that claim? If not, you can't make that claim. At least not in my book. I could be wrong on that, but I think I would be objecting to it. I mean, Mark Richards is allowing James Krause here to basically invent self-defense laws, and they're not accurate.
That's not really in any dispute.
That's not in any dispute? Really? So the defense is not going to dispute that? This is called truth by blatant assertion. And we hear it all the time when people say, period. That's just the way it is, period. There's no dispute here. It's a fallacy, and it's bad argument. He should not be doing this. He's a lawyer. He's gone through law school. He should know better.
I want to leave you with this. The meaning of reasonable doubt. I'm going to read portions of this instruction. Obviously, you'll have the whole instruction.
That's enough. I can't handle the guy. God, I hate him. I hate him more than Binger. I don't know what it is about him, but he makes my skin crawl. But whatever the case, he now joins the list of local lawyers.
With this bandana, I welcome you to the game.
Like my video and subscribe to my channel.